Student loans. As of right now, I'm actually looking into another aspect of student loans, especially for uh, people that have or thinking about filing bankruptcy, and they were wanting to file their student loans. They're allowing ever since November the 12th of 2022. They had enacted a guidance. It's a guidance because it's not really, they haven't finalized everything yet, but they're allowing people who have and you'll have to talk to a bankruptcy lawyer, consumer lawyer about the specifics to it. But ever since November the 12th, 2022 of last year, they're allowing people to, or consumers to, write their student loans off or add their student loans to their bankruptcy. So if you're thinking about filing bankruptcy and you want to put your student loans in it, there are some stipulations for adding your bankruptcy. Adding your student loan to your bankruptcy. So let me see if I can get a few. I was reading up on it. This also, they're actually targeting people who are in pending bankruptcy status and who are thinking about filing. Now, if you've already filed bankruptcy, then you actually have to talk to a lawyer about that because they can tell you the specifics. But I do know that there's more than there. You have a Chapter 7, you have a Chapter 11, you have a Chapter 13 bankruptcy. So it depends on the type of bankruptcy that you're trying to pursue. But I do know, it's November 17, 2022. So it states that the guidance states that it applies only to bankruptcy proceedings that were pending on the date the guidance was issued, which was November the 17th, 2022. It also states that it was talking about reopening. Yeah, one of the things they had a lot of questions about, and I actually sat in this, is the NCLC, National Consumer Law Center, where they have these lives and you get to watch. It's specifically for lawyers, but I was invited to it to where I got a chance to watch the free webinar. And they talk about a lot of law stuff when it comes to consumer law. But a lot of their questions, they had people asking about discharge bankruptcy. If you already had a bankruptcy and you want to go back and add your student loans to your bankruptcy, there's a way that you can. There are some certain stipulations. They call it. You have to determine what they call undue hardship. And they call it the Bronner test, the Bronner test. But it says that it may be discharged only if the bankruptcy court determines that accepting, those are the exceptions, such debt from discharge would impose an undue hardship on the debtor and the debtor's dependents. So you can also include inside of this Bronner's test, where they make this list of you showing your income, your expenses, your adjusted gross income, if you're paying out any health insurance, if your living expenses, your food, housekeeping, supplies. You get to list all of these things on there. And even if you have to pay for doctor visits for your child that was outside of your health insurance from your job, if you had to pay for any type of medications for you and your child, but the child, if you include this child, they have to be a dependent. They have to be your dependent in order to include this person inside of this list of undue hardships. All right, so in order to show that you can include your student loans inside of your bankruptcy, you have to present certain circumstances, future circumstances, and good faith. So what they're saying about present circumstances, they're saying something about the debtor cannot maintain based on current income and expenses. So if you got student loan debt and you know that you don't make, say for instance, we'll give a good example. Okay, we all know that if somebody owe, like, this is just me giving an example, we all know that somebody probably owe, like, I'm gonna say $20,000 in student loan debt. That right there is like $700 some a month. So if you think about it, if you don't make but what, I'm gonna say $1,000 a month, and you ended up having to pay your student loans, or your student loan was in default, that means that if your student loan payment your estimated payment is $700, you only have $300 to live off the income, and this is your net income that you bring home. This is what you actually use to This is after taxes. So after they take taxes and health insurance and stuff like that outside of your check, you only have $300. You can't survive off $300. You can't take care of no kids off $300. So that right there presents an undue hardship. So you actually have to look at your net income. You actually have to look at your there are a lot of things that they have on this list. But I do know that you have some people that are in like $100-some thousand in student loan debt. You have some people that are in like $200-some thousand in student loan debt. There's no way that those people, those consumers can maintain. And some of those people, as of right now, are not even in jobs that they got the student loans for the degree that they pursued. So it's actually like it's a lose-lose for them. So I feel like NCLC actually enacted this guidance. It's a great benefit, but you actually have to go through the process, and I can't give you any legal advice, so you'll have to get a consumer lawyer to help you with it. But I do know they're allowing people to include their student loan debt inside of their bankruptcy. Now, I know a lot of people right now are probably in like for forgiveness, loan forgiveness, and when I tried to look at mine, I know I'm in loan forgiveness, so they actually couldn't give me like an estimated how much I would pay per month for my student loans. I have to actually wait till I get out of it. But if you really want to know, you just call your servicer, your student loan servicer, and they should be able to give you a breakdown or pretty much an estimate of how much your student loan payments will be. So you can use that as a way to add on that list to see if you qualify to get your student loans discharged. And this is to discharge your student loans in your bankruptcy. Okay? All right, if you have a question while I'm talking about student loans and bankruptcy, go ahead and type them in the comments. Make sure you like and you invite more people to the group so they can get this information. As far as getting student loans deleted from your credit report, that's the easy part. There are a couple steps that you need to do. I do have templates for it. If you need templates, the link is in the comment box. You can click on it. So, let me see. It was another thing about they also stated something about the debtor pursuing this on their own, because this is like filing a lawsuit. So if you if you want to discharge your student loans inside of your bankruptcy, I would advise you to get a lawyer, because this is like filing a lawsuit against the U.S. Department of Education. Okay, so that's actually who the lawyers are going to sue, not per se sue, but you know that's who they want to challenge, the U.S. Department of Education. Let me see. It was something else that I marked where somebody they wanted to do it themselves, what they call prose. I wouldn't advise you to do that. But it does say that there's no filing fee if the debtor initiates the adversary complaint. So if you initiate the complaint with your student loan servicer, there's no filing fee for that. There's no filing fee for that. So even if you were to use a lawyer, it says an adversary proceeding is a lawsuit within the bankruptcy case initiated by the filing of an adversary complaint and is subject to bankruptcy rules that are almost identical to the federal rules of civil procedure. So it's just like you taking somebody to court, okay? Filing a complaint to sue. Under the present fee schedule adopted by the Administrative Office of the U.S. Courts, there is no filing fee for an adversary complaint brought by a debtor in a bankruptcy case. All right. Oh, another way too, also check NSLDS, go to your student loan account and see, you'll also need what's your total amount of student loans. So going to the NSLDS website, you can access that via the studentaid.gov website. And let me type that in, so just in case somebody curious. I do want to reiterate, when you on this website, please keep up with your passwords, because they're very strict about not remembering your passwords. Because, did I do that right? Yeah, I did right. They're very strict about it, and once you get locked out, you got to call to get them to unlock it. So be very careful. Make sure you keep up with your passwords on that one. You got to have a FSA ID. All right, let me see. This shows you your guarantee agencies when you see when you go to this website, your direct loan program, other education program. It should identify your lender. It should also it says, however, it is important that the current holder of the loan be named as the defendant. So if you're trying to pursue this complaint, trying to initiate this complaint, you got to make sure you got all your ducks in a row. You got to make sure you have all the information. And they list it here. If you got a question about that, I can give you the answer to that. Similarly, the guidance does not apply to holders of any private loans. So if you're wanting to include your student loans inside of your bankruptcy, if you got a pending bankruptcy or you're thinking about pursuing the bankruptcy, private loans don't apply. So, however, if a settlement is reached with education and other loan holders granting a discharge of the debtor's federal loans, this should put pressure on the private loan holders to follow suit. All right, so they're trying to tell them they need to. It's like they're giving them a warning on that one. It says the settlement process under the guidance is triggered by the debtor submitting a completed attestation form to the department attorney. Debtor's attorney should become familiar. Okay, so it's saying something about in order to get it started, to trigger it, you got to fill out that adversary complaint. You got to initiate that adversary complaint. If it's either you or the lawyer of your choosing. So they making it now to where you can include your student loans inside of your bankruptcy. Now, going back to people who already filed bankruptcy and want to put their student loans inside of their bankruptcy, you actually have to reopen. It stated that you'll have to reopen. Let me go back because I want to say the exact words. You have to reopen your bankruptcy case, either file it another way, because if you file Chapter 7, you do have the option to do a Chapter 13. I'm not giving any legal advice. This is me reading from the guidance that they actually emailed us after we got through watching the webinar. So, but your bankruptcy case can be reopened. But you have to prove undue hardship in order to get it discharged. It doesn't say forgiven. It says discharged. Student loans. It's a difference. I'm trying to find that sentence where they were stating that if you already had bankruptcy and your case is closed. All right, here it is. It says, while the reference to proceedings, make sure you listen, while the reference to proceedings rather than cases might suggest that the guidance would apply to an adversary proceeding filed after November 17, 2022. So if you file bankruptcy before, it says in a reopened bankruptcy case that was closed before November 17, 2022, we believe that the agency is intended to apply only to pending and future bankruptcy cases. Unless, rather than move to reopen closed cases, attorneys should consider alternatives. So there's an alternative if you've already filed bankruptcy and you want to include your student loans inside of your bankruptcy, discharge inside your bankruptcy. Attorneys should consider alternatives, such as whether in appropriate circumstances a former client may wish to seek bankruptcy relief in a new case and then file an undue hardship adversary proceeding in the new case. So I got you. All right, so if you already had a bankruptcy and you want to go ahead and you didn't get a chance to discharge your student loans in the last bankruptcy, your actual lawyer can move to reopen it and file a new case. So if you already filed Chapter 7, you can file another Chapter 7, but you can't do it within the 10-year window. So remember that. So if you've just recently filed a Chapter 7 bankruptcy, within 10 years, I know you can file another one for another 10 years. So if you're within that 10-year range, you might want to consider doing a Chapter 13. and then file an undue hardship adversary proceeding in the new case. So if you got overwhelming student loan debt, you can use this. You can use this. They call this the new process to discharge student loans in bankruptcy. Let me type that in. This is the new process. I don't know why I want to keep saying discharge bankruptcy. Now, I'm telling you this method because I do have a couple clients, they having issues. Anytime you're disputing something, you're trying to get something deleted from your credit report, a lot of companies are going to give you pushback. It's a lot of people say, oh, this didn't work, this letter didn't work. No, we took the time out to study the laws. The laws work. It's your persistence. It's your, if they deny you the first time, do it again. If they deny you the second time, do it again. If they deny you the third time, do it again. And if not, you have the FTC, you have the CFPB, you got the BBB, you have all of those resources or platforms that you can use to file your complaints. Okay? So don't just say that something doesn't work all because you tried it one time and you give up. That's why they say study consumer law, so that when you do it yourself, instead of using a credit repair person, which I'm not knocking credit repair. I did taxes for about 8 years, 10 years, 8 years. I think it's about 10 years. And credit repair is no different from doing taxes. So if you don't understand the process, understand these processes, I understand why you go get a credit repair company to do your credit. That's fine. But do you know what they are using to get your stuff removed or deleted? Because I've heard of clients having pushback getting these letters, don't know why these letters being sent. And now they scared that these people going to take them to court because they don't know what their credit repair person was doing. So if you learn the laws and learn how to do it yourself, you have nobody to blame but you. And when the results come out, you have stuff deleted from your credit report and your credit score go up, then yes, you'll be happy. Okay? So learn how to do some of this stuff yourself. Even the simple basics for deleting stuff from your credit report. At least learn how to do that. They should have this type of class in high school. They took away home ec, call it what? They took away home ec, calling it culinary arts, which is still not. And then they got what? Babysitting classes now that kids can do. Nothing dealing with home ec anymore. So we need to learn the little basic stuff about credit, because credit is like money makes the world go round. But credit is power. Okay? Credit is power. You can get money from credit. So learning the basic consumer laws, and if you don't know, I do have consultations where I can teach you this. Click the link, my Linktree link in the comment section. I can teach you that. You can join my YouTube channel. My YouTube channel. I have videos. The laws that I state in my videos on my YouTube channel, write them down. Write them down. It's all this information is public information. It's free information. The thing is, when you start to pay for it from somebody, it's because that person, they work to get that information. They work to combine that information so that you can use it and get stuff deleted from your credit report. So it wasn't that like, okay, say for instance, we got a charge-off letter. It wasn't like the laws that we spit inside of the charge-off letter. All of them was in one place. No. We literally had to go to different places in the laws of Congress to get that information and combine them together so that you can already have everything in one place. So it's not like this stuff just was in one place. So don't think that. I had somebody tell you, I'm gonna be transparent. I had somebody say, "Why are you charging me this much for this charge-off letter?" I said, think about it. If you go watch my videos on YouTube, I teach you how to do it. I'm giving you the sauce right there inside of the video. Not trying to say it to be funny or anything, but if you would take the time out to watch it like you watch movies, like you watch TikTok, like you watch these fights, like you watch all this negative stuff on TV, Take time out to learn something. Take time out something to educate yourself. And those videos, what, an hour? About as long as, I think some of my videos like 30 minutes, 40 minutes. I got some that's an hour. That's like watching a regular movie. But, and then too, a lot of this information that you learning from me, that you learning from any other credit guru, use it, make money off of it. You can use it to make you run your own business. You can use it to run your own credit repair business. You can use it to help others in your family. It's not, it's like generational wealth sitting right in front of you. But we take the quick route. We're in this microwave society where we take the quick route. I'm going to pay you for it. You do it for me. And then when something backfire on you, oh, how you do that? I had to pay this now because so-and-so did this. If you'd have done it yourself and learned it yourself, you wouldn't have nobody to blame. You just figure out what you did wrong and start all over again. Yes, you can start the credit process over again. Just because it stopped in one spot doesn't mean that that's it. No, start it over. Start the dispute process over again. You're a consumer. It's your right. It's your consumer right. All right, so let's talk about late payments real quick. If you have any questions about late payments, I'm going to give it about another 10 minutes and I'm going to hop off. So I just want to just reiterate some of the things. Because it's tax season, y'all. I do have that secret lenders list that I'm going to... I will also add to my link tree. That'll be in so you can know exactly, once you get your credit score together, you can use that secret lenders list so you can know exactly what credit score you need, so you can know exactly what creditor you want to pursue, what credit bureau, and you know there's no such thing as credit bureaus, but what credit bureau you want to pull, that they pull from. So when you apply, you already set up for success. Okay? So let's talk about late payments. And this, my late payment letter, you'll send it to the actual furniture creditor. So we'll do 15 U.S.C. 1681B, permissible purpose. First of all, in order for any company, finance company, or creditor to be able to extend your credit, they have to have permissible purpose. Permissible purpose means when they check your credit, pull your credit, it will result in an inquiry, right? I do have an inquiry, a 24 to 48 hour inquiry deletion guide that you can also purchase, and it's on everything that I'm listing is on my link tree. You just click on it and go to whatever you need. But they have to have permissible purpose, written permission from you. And when I say written permission, if you went in a finance company, you didn't fill out an application, or you might have done it online, be very careful. Please read your applications. They'll give you like little links that you can click to go look at something. Please take the time out to read those, because sometimes when you're online and you're signing stuff you have no idea you signed or you gave permission to do. So I don't know what's wrong with my throat. So make sure you click those links and read those links and see what they're saying. If you're confused, because what they do is that you do it online, you have nobody to ask questions to. So just be mindful. If you have to sit there and write it down on a piece of paper, write it down on a piece of paper, or write little stuff down from there. But write something down, because you don't want to sign away your rights. So even if you were opted in when you apply online, you do have the option to opt out. And that's for finance companies and creditors. That's not for debt collectors, okay? So don't use 6802, opt out. Don't use 6802 for debt collectors, okay? It's for finance companies. But I will say, if you're trying to opt out of credit report, if you're trying to use that as one tactic. Now, what I use to get things deleted from your credit report, that's just one of the many ways you can get things deleted from your credit report, okay? But I will say, if you're dealing with a debt collector, you want to see if they own the debt. So if they own the debt, then you also want to check to see if they have to abide by the same rules as the creditor. Because if they bought the debt, or even if they didn't buy the debt, if they're going to report anything to your credit report, they have to be able to abide by some guidelines too. So if they're representing a creditor, yes, they're going by the rules of the creditor. So everything that applies to the creditor applies to the debt collector. But if the debt collector is a debt buyer, then you need to see what type of disclosures they got. Ask them to validate the debt, and check to see if what type of guidelines they follow. When I say guidelines, I'm talking about opting in to credit reporting. I'm talking about arbitration, because sometimes when you sign something or when something being sold to another company, the arbitration clause will go along with it, and you have to make sure you read it, because your creditor does have statements inside of the arbitration clause that says that this also pertains to any third party entity that we transfer this debt to. So you do have to be mindful of that. You can use that to your advantage too. So they must have permissible purpose, written permission by you, the consumer. Okay, if you didn't give them that written permission, then by law they're not supposed to be even. They're not supposed to even have access to your credit report. Okay. Another way to get things deleted is to attack the credit bureaus, because they fall under the category of the 1681 B also, because they have to certify this information. This information must be certified before they can allow that information to be shared. But I will tell y'all, these companies don't care. They don't give two F's. They don't care about you. Okay. They make money from sharing your information from one company to the next company. So if a company tell you that they're not a furnisher, by law they are furnishers, because if you're furnishing this information to a consumer report, even if it's just a consumer report dealing with bankruptcy, even if it's a consumer report that's just dealing with credit cards, even if it's a consumer report that's dealing with payday loans, installment loans, they're issuing a consumer report. So if they're building or if they're procuring a consumer file on you, if they're procuring a consumer file on you, they're creating a report about you. So they fall under those categories too. They'll try to send you something back and tell you that they're not a data furnisher, that they're not furnishing information. Some companies use it, and there are a lot of consumer reporting agencies out there. You just have to know what type of consumer reporting agencies they are, so you can be better prepared or better equipped to attack them, so you can get these items deleted from your credit report. All right, so when we're talking about furniture, we're talking about 15 U.S.C. 1681 S2. So a furnisher of information is prohibited by law to furnish incorrect and inaccurate information. So you're going to demand that they cease and desist all reporting. This has something to do with like finance companies, like credit acceptance, auto dealers, not auto. Well, if the auto dealership is the actual finance company, then yes. We're talking about Credit One Bank. We're talking about World Finance. We're talking about all those creditors, those credit card companies. Those are furnishers, especially if they're furnishing, like Navy Federal, those type of companies. If they're furnishing information to your credit report, they are furnishers. Now, some will say that they're not data furnishers. They use that. But if they're giving information to another company, then they're considered a data furnisher. If they're procuring a consumer report for you, then they have to abide by laws to keep your information private also. So if you look at 15, when we're talking about late payments, if you look at 15 U.S.C. 1681A, it clearly states that reports containing, we're talking about a consumer report, reports containing information solely as to transactions. So what is a late payment? Isn't a late payment a transaction? Think about it. I need to use think about it. Hashtag think about it. Oh, let me try that. Think about it. All right. So if your credit report doesn't supposed to have information solely as to transactions or experiences between the consumer and the person making the report, that's the company. You're not supposed to be reporting late payments. Okay? You're not supposed to be reporting late payments. That's in the exclusion section of 1681A, D2, exclusions. Okay? Exclusion means to what? What does exclusion mean to do? Not supposed to be included, right? So they're not supposed to be putting, boy, so much stuff I could tell y'all right now, but they're not supposed to be putting reporting late payments. Okay, that's how you're gonna get the late payments deleted. Um, you can use these laws and create your letter. How you don't even have to use my letters. Okay, you don't have to use my letters. Use the law, read the law, study the law, get an understanding of the law so that you can create your own letter. Okay. Um, and if you send your own letter and you got questions, contact me. I don't mind helping. I'm finna my consultations for my 30 minutes. They're going on sale for another week, another flash sale. I did real good with that. So I'm gonna continue that. You'll see I put up my flyers. You'll see that they're going for $40 instead of $75. That's the 30 minute one. So I'm gonna have them going for $40. Okay. So if you sent your own letter out, now when you contact me, you have to be very transparent on what you've done before you contacted me, because I have some people will say, "Oh, I need this deleted." First, I sent this letter, but I need to know what was in that letter that you sent, and I need to know like the steps you did after that or what you did up to that, because I don't want to tell you to do something and you purchased this letter or you purchased this from me and it don't work, all because you weren't transparent about what happened before you even contacted me. Okay, so you have to be transparent when you contact me. Okay. Medical debt collection. Anybody with medical debt collection? They're actually cracking down on medical debt collection. I'm hearing people getting checks getting garnished because of medical debt because they know they can't report it. So they'll wait 6 months and they'll send they'll file a lawsuit complaint against you and try to get a judgment against you. Now it's from 6 months to a year. So if you just if the date, let me give an example. If you went to the doctor, so this was just enacted in 2022. So I say, if you went to the doctor August of 2022, they're supposed to give you a year before they even pursue any type of collections on that account, because that's giving you time to assess the debt, to fix the debt, to pay the debt. So if you went to the doctor in August of 2022 and they turn around and say August, September, October, November, December, January, February of 23 this year, and they turn around and they're trying to garnish you, they just send a complaint, they just file a lawsuit, and they're trying to sue you, they can't sue you. They can't sue you. So if you have a medical debt that you just recently incurred, and it was after July 2022, you can use this. You can use this to get it deleted or to stop that lawsuit. Okay, because they have to be up to a year before they even try to pursue any collection activity. Anything less than $500 in a medical debt collection or medical accounts that's less than $500 will not be reported on your credit report anyway. Okay, so as of January 2023, no medical debt collection under $500 will be reported, period. So what they're going to try to do is, since they know that they can't report it, they're going to try to hit you with their lawsuit. So that's why I'm telling you, if it hasn't been a year, they can't sue you yet. They have to wait up to a year before they can pursue any type of collection activities with that account. Starting July 1st of 2022, the time before unpaid medical collections can appear on a consumer report will be increased to 180 days to 1 year. So from 6 months to 1 year, that's what I was telling you about. Any paid medical collections will no longer be reported on your consumer report. So if you got a paid medical collection on your credit report as of right now, it needs to come off. If you don't know how to do it, my link tree, you can get a consultation with me. They're going to go on sale. I'm going to change that as soon as I get off this live. But I got 5 more minutes before I get off of here. So if you got any paid medical debt collection, they don't supposed to be on there. Okay. So because as of right now, no paid medical debt collection is supposed to be on your credit report. Depending on your state, you also want to check your state statute of limitations for a furnisher or a creditor to sue you. Okay. Check that too, because you may have a debt that was before 2022, which 2021. And it's been Mississippi, the statute of limitation for anybody to come sue you for a debt is 3 years. So if it's been more than 3 years, and when we say 3 years, 3 years starts. A lot of people have an issue with this. 3 years starts from the first date of delinquency. And what we mean by the first date of delinquency is that you were late on January 1st and you haven't been current since. You haven't brought it to current status since. So you've been delinquent the entire time, okay, from the first day of delinquency. This changes your first day of delinquency and your 3-year statute of limitation. Is if you were late in January, February, March, you were late 3 months, but then you turn around in April and you make a payment, you just restarted that clock again. Okay? You've restarted the 7-year clock, and you've also restarted your statute of limitation clock. Okay? So just be mindful of that. So check to see if that first date of delinquency, you never brought the account current. If it's past 3 years, put that in the letter. Say it just like what I just said on the video. It don't have to be nothing fancy. It don't have to be nothing educational. You don't have to sound intellectual like you're a lawyer. No, you can just write that in there. It's been over 3 years. So. I demand that you delete it. I'm not asking. I'm telling you to delete it because the law states. You can also get this information from CFPB website too. So you can go to Google. You can type in medical debt collection CFPB, and it'll take you. You can see the links to where you can go click on and kind of read around and get an idea of the medical debt collection. Auto loan disputes. Before I chime off, I got 2 minutes. So auto loan dispute, because I gotta go. On the auto loan disputes, I have a lot of people asking me about getting their down payment back. May I please reiterate, when you watch my video on YouTube, it's not saying, okay, yes, down payments are illegal, because you're not supposed to, if you pay cash for your down payment, you're not, 15 USC 1605, you're not supposed to mix a cash transaction with a credit transaction. True. But in order to use this, you have to have leverage. You have to check to see if there are certain type of violations that you have on your auto retail installment contract. I'm gonna give you a list real quick. Your APR, that's your state maximum. You need to check your state maximum usury law. State tax for motor vehicles, so check your state tax for motor vehicles. Finance charges, that's that 15 USC 1605 down payment. Check your gap insurance. Did they tell you when you was in there on that visit that it was optional? They supposed to tell you it's optional. They may have it written in your contract, so they're going to use that against you. But if they didn't tell you that, they didn't disclose that to you, they're going to use it if they put it inside of there. But you can also request for that back, letting them know that you didn't tell me about this. Check your service contracts, optional charges, especially dealership provided service, because some service contracts are done by the dealership. That's them getting that money back. So think about that. Your insurance terms should match the number of payments that's on your truth in lending statement. That's the part of your retail installment contract where you got those 4 boxes. So your insurance terms should match on that service contract. Your insurance terms should match the number of payments. Because if not, if it's shorter, if your service contract is shorter, let me see. Yeah, shorter. That means they owe you money. Okay. Check certain disclosures needed to be included in the retail installment contract. So ask them about any type of disclosures or request everything from them. If you're contacting the actual finance company, request your disclosures from the finance company. If you're lucky, go look in your stash somewhere and see if you still got your retail installment contract papers from the dealership in there. If not, call a dealership and ask them for it. They supposed to give it to you by law. Okay? They're supposed to give it to you. And when you get those two, compare them. Compare them. Because if there is any inconsistency between the dealership and the finance company, the dealership may be at fault. You can get your down payment back, especially if you paid cash. Did you not hear what I just told you? Okay? All right. I'm going to chime off. I left my Linktree link. Any letters you need, click it, shop around, look around, let me know. I also want you all to become a member of my YouTube page so you can see these how-to videos when I go live. I'm only answering questions for my members. Okay? So if you're a member of YouTube and you ask a question, I might like your post, but I'm not going to answer your question because that's one of the perks that my members get on the YouTube. So if you're not in my Facebook group, and if you're not on my YouTube channel, emails will only be for customer service. Okay, so starting from today, emails will only be for customer service. All right, that's if you've purchased any of my products and you need assistance with it. Okay. All right, I want to thank y'all for being my members on my Facebook group. Thank you, thank you, thank you. Peace out.